Ken Carlson. I've been an attorney helping tenants since 1980, and I run the caltenantlaw.com website. This video is about the eviction process itself. I created the game board as a flowchart to help you understand how the process works and to map where you are in it. There are other videos discussing your rights and strategy for different types of evictions, and more detailed ones on each of these sections if you want to know more. The eviction usually begins with an eviction notice. After that notice ends, the landlord files what is called an unlawful detainer, the official name for an eviction lawsuit. You have to be properly served with the summons and complaint package of papers. It's usually not properly served, so you file a motion to quash to challenge the improper service, but nothing else. If you weren't even named in the case, you can join in by filing the prejudgment claim, followed by your motion to quash. The motion to quash hearing is usually a week or two later. The landlord may file a response to it. You don't even attend the hearing, but check on the results later. If you win, the landlord has to serve you correctly, and you can file another motion to quash as to that. If you lose, as usually happens, you can do a mini appeal called a writ of mandate, a form of appeal to the higher court to reverse the judge. If you get the writ, the trial judge has to obey the appeals court, like granting your motion to quash. If you lose the writ, you still have 15 more days from their mailing, the notice of denial, to file your demurrer. If you have a foreclosure eviction situation or other issues that involve federal law, you can file a notice of removal to transfer the eviction to the federal courts. That stops the eviction case temporarily. Usually they refuse to hear it and send the case back to the trial court, but that part can add several weeks to the entire process. The motion to quash said you didn't get served properly. The demurrer says you didn't get accused properly by the complaint. It's not your side of the case. It's very technical and is usually limited to what the complaint itself says. The hearing on that is a week to a month later, and you don't attend that either. You check the results afterwards. The judges usually deny your demurrer, but at least you got that extra time by filing it. If you do win it, the case could be thrown out, or the landlord could fix the mistakes and try again. If you lose, you still have about 10 days to file your answer. After the motion to quash stage, but before the demurrer is due, you need to start filing discovery. This is your right to ask the landlord questions, to admit things, and to produce evidence so that you are not surprised at trial by his lies. Landlords avoid telling you anything because they know they're wrong, and you have to follow through with a motion to compel. That motion is to get the judge to order your landlord to answer the questions, produce the evidence, and reimburse you for the cost of filing it. If that motion is granted, usually the trial can be postponed until after you get the updated answers. If the judge denies it, you're stuck with what you got, and you know the judge will be unfair at trial too. In the middle of the game board is the default section. Default means you lose by not doing something. Evictions have strict deadlines, so if you miss one, default could happen. Clerks and judges also make mistakes, and you can expect lies from the landlord, his lawyer, and his process server. You need to know that if you are defaulted, it's not game over. You just need to unlose. If it was your fault, you file a motion for relief. If it was not your fault, you file a motion to vacate. It's the same result, undoing the default and putting you back where you should be. When you file your answer, that is your side of the case. It's not detailed and you don't have to attach evidence to it. You deny what the complaint says and add affirmative defenses, which show why you should win. There are many, ranging from an illegal late fee to an illegal building. You also ask for a jury trial, which greatly increases the landlord's cost and risk of losing. It gives you a lot of leverage when it comes to negotiating a settlement on the day of trial. Before you get to trial, there is a way to win or lose called a summary judgment motion. It doesn't happen often, but it is one way that the battle can stop. To win the motion, you have to show that the landlord has no possible chance to win, even assuming everything he claims is true. It has to be filed after the answer is filed, and it can be set in as little as 5 days. It can be as simple as a technical detail, like the landlord filed the case a day too soon. If there is any chance at all that the other side is right, the motion is supposed to be denied. The problem is that corrupt judges grab it as a chance to help the landlord win and avoid the scrutiny of a trial. Since you are choosing a jury trial, you need to get the paperwork together and organize your case. So does the landlord. Witness and exhibit lists, jury instructions, and prepared exhibit books are among the things to be prepared. The judge will usually have a meeting to go over these papers, as well as what is called a Mandatory Settlement Conference, or MSC. The MSC is mandatory to attend, not mandatory to settle. It is the last-ditch effort to settle the case without the time, expense, and risk of a jury trial. It is usually the first day of trial, before a jury is called in. That is where the landlord will usually buckle and agree to a settlement that's favorable to you. The better prepared you are, the more confidence you will show, and the more likely the landlord will be afraid of losing. You have dragged out the case so long by this point, and the landlord's expensive lawyer has been helpless to stop those delays, so the landlord has little confidence in his lawyer. The judge may even chime in and try to bully you into a settlement favoring the landlord, but that's because he also thinks a jury would help you. Stay strong. Be reasonable. If you do go through trial, it's quite a challenging experience. You can win fantastically, but due to the judge's unfair rulings and sabotage, you could lose. If you win, you continue in possession, but without paying rent unless and until you make a new rental agreement with the landlord. You can also sue the landlord and his smug lawyer for trying to evict you. If you lose, you can appeal because of the judge's errors and get the judgment reversed. You can stop the eviction while you're going through the appeal by another special procedure. If that doesn't happen, you can continue with the appeal, but you have to move. Even if you lose the eviction and the appeal, you can still sue the landlord for evicting you and everything else that you endured. That's it for the overview of the game board. For the individual portions and the many grounds for your defenses and other strategies, watch those videos before you set up a consultation with us.